Hello everyone. Today I'm going to tell you some of the key concepts of the Indian Evidence Act. So let's start with the facts typically mean a piece of information that is objectively true and can be supported by evidence. Facts are distinguishable from opinions, beliefs or interpretations which may vary from person to person and are not necessarily grounded in verifiable evidence. According to Section 3 of the Indian Evidence Act 1872, facts includes and means anything, state of thing or relation of things capable of being perceived by the sense or any mental condition of which any person is conscious. Now let's proceed towards what is fact in issue. Fact in issue is an essential step in framing legal arguments, presenting evidence, and ultimately reaching a resolution in a legal dispute. The Indian Evidence Act 1872 provides a framework for presenting and establishing facts in issue through the admission and examination of evidence. As you can see here, in example, in a criminal trial, the facts in issue may include whether the accused committed a specific act and whether they had the requisite intent. In a civil case, the fact in issue could involve questions about contractual obligations, property rights, or negligence. Now, let's move towards relevant facts. Relevant facts are those facts that have a direct bearing on the matters at issue in a legal proceeding. According to Section 5 of Indian Evidence Act 1872, which defines relevance and irrelevant facts. According to this section, evidence may be considered relevant if it is connected with or is related to the facts in issue or if it makes the existence of any fact in issue more or less probable. Relevant facts in a legal context are those facts that have a significant and direct bearing on the issues in a legal proceedings. When presenting evidence in court, parties aim to introduce relevant facts that support their argument or dispute the opposing party's claims. Now, let's move towards the evidence. In legal terms, when we say evidence proved, it means that the evidence presented in a legal proceeding has been established or demonstrated to the satisfaction of the court. The process of providing evidence involves showing through admissible means that certain facts or assertions are true. Now, there are some of the key concepts of evidence proved. The first concept is burden of proof. Burden of proof rests on the party making a particular claim. The next is standard of proof. The standard of proof may vary depending on the type of cases. In criminal case, standard is beyond a reasonable doubt, and in civil case, the standard is preponderance of the evidence. The next is admissibility. For evidence to be considered proved, it must be admissible in court. Next is evaluation by the court. The judge or jury evaluates evidence presented by both the parties. Now let's proceed towards what are the disapproved evidence. Disapproved evidence refers to evidence that the court or legal authority has not accepted or has rejected as unreliable, irrelevant, or inadmissible. There can be various reasons why the evidence has been disapproved. Some of the reasons are: first is relevance. Facts that are not relevant are regarded as the irrelevant facts. Second is unreliable or speculative. The facts on which the court cannot rely are known as unreliable or speculative evidences. Improperly obtained evidences. Evidences obtained unlawfully, such as violation of constitutional rights or in breach of legal procedure, can make the evidences disapproved. Violation of rules of evidence. Violation of rules and evidence includes failure to adhere to established rules of evidence can lead to disapproval. Opinion without expertise. Opinion offered by witnesses without necessary expertise or qualification may be disapproved. Prejudice or unfair evidence that is likely to unduly prejudice the jury or is unfairly prejudicial may be disapproved. Now let's move towards proved not proved evidences. Not proved evidences refers to those evidences that has not been established or demonstrated to the satisfaction of the court or legal authority. In legal proceedings, parties present evidence to support their claims, but not all evidence may meet the necessary standards for acceptance. Now, let's talk about oral evidences. Oral evidences refers to the spoken statement by the witness during a legal proceeding. It typically includes the verbally and typically in the form of witness testimony as opposed to written or physical evidence. Now, some of the key points regarding oral evidence are: first is admissibility. Oral evidence is generally admissible in court unless it falls under certain exceptions. Witness testimony. Witness providing oral evidence by testifying about facts within their knowledge or observation related to the case. Direct and cross examination. It involves direct examination of witnesses by the party calling them or cross examination of the opposing party. Oath or affirmation. Witness usually take oath or make an affirmation before providing oral evidence. Refreshing memory. Witness may refer to document or other aid to refresh their memory while providing oral evidence. Recorded statement. In some cases, oral evidences may be recorded, such as through audio or video recording. Now, let's move towards what are the documentary evidences. Documentary evidences refers to those evidences that are proven or established through the documents or through written records. In legal proceedings, documentary evidence is often crucial for establishing the truth or verifying the existence of certain facts. For documentary evidences, there are some key points for its validation. So let's see that. The key points regarding documentary evidence, the first one is admissibility. Admissibility means that the documentary evidence is admissible in court. Authentication. Authentication means to be admissible, documentary evidence needs to be properly authenticated. Public and private documents. Public and private documents includes the different type of documents. In public document, it includes the government records, and in private documents, private contracts or letters. The next is best evidence rule. The best evidence rule suggests that the original document is the best form of evidence. Next is secondary evidence. If the original document is unavailable, secondary evidence may be allowed. It includes the hard copies and the soft copies of the evidence. Hearsay. The context of document are generally considered hearsay if offered for the truth of the matter asserted. The last is weight of evidence. The court assesses the weight and significance of documentary evidence in the overall context of the case. That's it. Hope you have liked the video. Thank you.